kama abi balani ito ado
This meeting is being recorded.
mi ado nudibe kama banyamo ang hilala ba ka indication mi deva mi screenshot kung ba kuri gende talba balang ito fa kuri gendana mi mi slides tami haro fennani kama mi balani denga mi kuri agenda iro gast kurani ingires bahon kuri agenda nga mi contract law huri abe furnace agreement aga nawane mi wujud wegen asa mi wani mi follow kura komando nizam di tereng ingires case law ge tereng hen kamo egri bay dimala dimge kuring mi tenne ko tanga sa huri mang mi ko kiyo tin mo gas mi ben kurani mi slides ta bima mi na mes hama de baves ekwekiga gende dande hama mi meantime bes farat ko ale suali kolla ben miamo hama e kolli mando explain kol de thomas ke kurana mi mi wagut mi benum kurani business laws kiawa students ko mi ACCA adi fada hin mi field tak business area related students business law kiyo mataka benum pura buying UK get by slides ta mi benum kurani okay mi idari beflong ada yagin kolla devon idin aron gado clear ko libe ko to
det er det vi begge to.
Hur det bägge?
okay so I'll be explaining this like I said in English, and as you can see there can be many agreements. Every day we do agreements. So what we'll be learning here is contract law. So the first thing that I would like you to know, or I don't know, we'll be having interactive sessions that you'll be responding to my questions. It's quite difficult for me to have this online because usually I would be teaching in a lecture where all my students would be in front of me, but this is quite a unique experience. So there are these difficulties. So when you go home, you have agreements with your family members. When you go to a coffee shop, when you go to every day, when you are in the workplace, you have to deal with agreements. When you meet with your friends, you have agreements. So what's the difference between this agreement and contract? Is there anyone who would like to have a thought? The difference between a contract and an agreement. Anyone? Okay, I'll carry on if I'm assuming that there's no response at the moment. So basically, those agreements there that you can come to court and have it enforceable, those agreements are contracts. So basically, not every agreement, you might agree to go to a coffee with your friends, but can you take your friends to the court for not agreeing? After agreeing and not attending to the coffee, can you take that person to court? No. But if the agreement can be enforced, those types of contracts, then you can come to court. Business contracts, let's say for the time being, those you can enforce in a court of law, then that agreement becomes a contract. Now, you have to know that in today's world, it is quite different compared to how these laws came about 150 years or so, or even more. The case laws that we refer in English law, these have been there for so long. But today the world has changed. And in my first slide, I'll be talking about standard form of contracts, but you can see the definition of a contract. Basically, here you'll see contracts are agreements which legally bind the parties, legally binding. So those are agreements which I explained earlier, that legally binding here means that it is enforceable in law. Now, the underlying theory is that the contract is the outcome of consenting minds, which we all know that one of the essential factors or elements of contracts is consent, which we'll be dealing later. And there's no basically form of contract, as we all know. Um, it can be in written form, it can be orally, it can be by action. So parties are judged by what they have said, written, or done. Okay. Now, I was going back to the point which I earlier regarding the times that they have changed. And today we do have lots of contracts with different service providers, electricity companies, phone companies. They are those that are providing. And you can see originally when the law was basically formulated through case law, usually it was between two consenting parties who were of equal footing, basically. But in today's world, that is something we rarely see. If you even want to build your house, you would have to, if you're taking a loan, you will be agreeing to the terms without much of a choice, the terms of the bank. Similarly with the contractor. And if you want your electricity, you have to have basically the agreement, or basically you have to agree with the agreement given by the electricity provider. And I'm pretty sure that you'll be quite familiar with the phone service providers. In fact, the software itself, you can't even access to your phone unless you say that you accept basically the terms. So in today's world, in this consumer driven world, you will see that there's quite a bit of inequality of bargaining power. Now, so are the parties of a contract on the same footing as like before in today's world? Well, with regard to these type of consumer type of contracts, you can say that there's hardly any bargaining power for the consumer. Now, in order to tackle that issue, in countries like UK, they have consumer protection agencies. So there's the Office of Fair Trading in UK and similar offices in all the Commonwealth countries, especially the Western countries. And then also the legislations, they have Unfair Contract Terms Act and Consumer Credit Act. In Maldives, we have a Consumer Act. Which you will see in the screen now. This is what we have at the moment. Okay, it might be in the drafted in the 90s and passed by the legislature in the 90s, but it's quite interesting if you go through it, and you'll find that a lot of principles are there. The point that I'm trying to make is that it is rarely exercised in Maldives because it is quite fairly recently lawyers were more engaged in these types of transactions, and the everyday consumer wouldn't bother to go through the hassle of coming to court to fight for their rights on these issues. But that law is there, as you can see. You can see that here at the bottom, the factors affecting the validity of a contract. Okay, so if any of these: capacity, form, content, genuine consent, legality, these, if any of these are affected, then the contract's validity is affected. Usually when we study in law school, you'll be learning these in a way like offer, acceptance, consideration, intention to create legally. Those are the essential elements for any contract to begin with. And then the ones that which I mentioned are the ones that would affect the legality or the validity of the contract. Okay, as you would know, there are valid contracts that you can enforce is once you prove that the elements are there, then that is basically a valid contract. Then we have the void contracts, that these are the ones that can be, after going through all these elements, that you can decide that this is a contract that will not be considered as a contract, merely may be an agreement. So it can be from the initial stage itself, which we call it void ab initio. And then we have the voidable contracts. Okay, that is the type of contracts where one party, or let's say in law we call the innocent party, gets, like, if for example someone misrepresented to sell you a phone, but you still like the phone now that you have. The person might have said to you during the time of sale that this is a brand new phone, but once you got it, you realize this is not brand new. There are contents that of the previous owner, and you now have a choice whether to terminate it or consider it as void, or to continue with it, to make it valid. So voidable are those where between void and valid, the contracts that are in between, and usually the innocent party is given the chance to avoid the contract or to continue with it. So he gets to decide whether to make it a valid contract or to choose that it is a void contract and try to terminate it by going to court. Then these are, and then you can see there are unenforceable contracts. This contract is valid, but performance by one party cannot be forced. Okay. Now this can happen, for example, due to basically change of law. You had a valid contract at the beginning, but now law is changed, so there's no way anyone can make the contract to be performed, because the law, for example, two people were doing a business and suddenly the law requests that business to be registered, and if the parties are not having it registered, then there's no way that the contract to be enforced. So that situation would fall under unenforceable contracts. I hope you guys are following. Now, a contract can be in any form. We always say that. However, there are situations. Okay. Now, the text that you are seeing is in UK. Okay. It is always good to learn about other jurisdictions. Here you will see that a contract can be in any form. It can be inferred, it can be written, okay, inferred from the actions, written, which is obvious when you write something, and oral, okay. However, there are three situations in UK where contracts can not be in any form that they want. It should be always written, okay. And those situations are contracts by deeds, okay. Land transfers, leases for more than 3 years. You can't have it in by words or by actions. It should be in written form if it is more than 3 years. Contracts which must be in writing. Transfer of shares here in Maldives, so you can't have share basically transfer without the proper documentations. And there's a process for certain types of contracts in Maldives. For example, land transactions. Okay, there are certain procedures prescribed under the Land Act that has to be followed. Okay, and even so, bill of exchange and tax, consumer credit contracts, sale and interest in land, transfer of shares. These should be in written form. The previous ones, that should be contracts by deeds, these type of transactions, what leases, conveyancing, and promises not supported by consideration. Basically, the type, for example, gifts that you want. Here, which in Maldives we can say something like Waqf. And contracts which must be evidence in writing. Okay, for example, if you give guarantee to someone, then it should be in written form. Okay, so there are similar laws here in Maldives depending on the type of transactions. Okay, when you are dealing with company law or these business organizations that we have under our laws regarding to businesses, okay, whether it be banks or whether it be companies. And the other main category is land transactions. Okay, these ones here in Maldives also, that requirement will be there, that it has to be written. Now, we'll be moving to the as you can see now, we generally talked about the definition of contracts from, and then the essentials of contracts, the form of contracts, and now we are here, offer and acceptance. An offer is a definite promise to be bound by specific terms. You can see that it is a promise. So offer is a promise. By its nature, it cannot be vague. So meaning that it has to be clear. Okay, it can be made certain by reference to previous dealings. What it means is that in this case, it was decided that if you say that offer is not clear, then at least you have to show, you can prove that during this particular transaction it might not be it might not have been clear, but based on the previous dealings, that you can show that, for example, that the price of certain goods every month, every year, you keep, if you are the seller, you keep sending the goods to islands, and no one talked about the price, and suddenly there's a dispute about the price, and now can you say that the price is not clear, the contract is vague? In Gunting versus Lane, it was decided that by giving reference to previous dealings, it can be made certain. Okay, in other words, it can be made clear. Okay, now it does not have to be made to a definite person, but one person can make an offer to the whole world at large. This was decided in the very famous, we all know, the Carlisle's case. Now we'll go to Carlisle's case in a while. Okay, but for now, this is the main case that defined the features of an offer and basically what an invitation is. Now, supplying of information is not an offer. If you keep asking about the price and when the other party responding, that is not an offer. Okay, supply of information is not an offer. However, if the vendor states the lowest price he will accept for a sale, that statement may be an offer which can be accepted. So here are some interesting cases, as you can see. Now, I mentioned about the Carlos case and invitation. So what is an invitation? An invitation to treat is an indication that a person is ready to accept offers with a view to a contract. So inviting people to make offers, that is what an invitation is. It is something that happens prior to the offer, prior to the contract. Okay, it is not part of the contract. It is something that goes before even an offer is made. So the first thing would be the invitation, if it is ever there. Then the response that comes to the invitation is always the offer. Now, why is this case, the case of Carlisle, relevant? This is a situation where the case of Khalil, not to go to the facts of it, but as we all lawyers um, who have studied law knows that the rules of offer and invitation, offer acceptance, many of the precedents were set in that case. And what you need to know at this point is there was an advertisement in that case. And we know that advertisements are generally considered as invitations when you advertise. However, Khalil's case is the exception. It was an advertisement. However, all of the features of an offer was present in that advertisement. So an advertisement, this is where we have to be careful. Even though a party who is making the advertisement, whether it is on a newspaper or in any other platform in today's world on internet, if the advertisement fulfills the characteristics of an offer, then that advertisement can be an offer. It will not be an invitation to trade. We all know in law always, the first thing is we lawyers, but we should know is there's always the general rule and the exceptions. The general rule is that advertisements are invitations. Okay, but the exception is that advertisement can be offers, was seen in the case of Khalil versus Kabul Exmobil. Now, other examples include auctions. In an auction sale, the bids that come, that is the offer. The advertisement of or the auction, the first inviting the people to come and bid, that process is the invitation. So auctions would usually start with the process of invitations. Okay, and bear in mind that we are talking mostly here about the general rule. It is up to the parties to prove otherwise. That is the point. Okay, now we know that the goods in shops, they are not okay. If we strictly speak, it is not offered. It is always the customer that when the customer presents the goods to the shopkeeper, to the counter, that is where the offer is made. We've all learned this. So basically, we are just recapping of what, or refreshing our minds of what we've learned years ago, aren't we? Now, acceptance. Acceptance is a positive act. Can you see? It's a positive act, it says, by a person to whom. That means if a person keeps silent without doing anything positive, or that will not be acceptance. As we know, silence is not acceptance. So something has to be done by action, by words, okay? But keeping idle will not make a contract. And remember, it is always that offer and acceptance tying together. That is the first essential part of a contract. Then we look into the other essentials, mainly the consideration and intention part. Okay, these are the first two things that has to basically match. Okay, Now, if unconditional, the act creates a binding contract, which means you can't ever have a contract when there's one offer made by one party and the other party basically says, I accept, but I want it to be like this. That is not acceptance. That is where a situation where a counter offer has been made. Okay. So if the accepting party brings a new condition, remember it's always a counter offer, as you would have learned. Now, communication of acceptance. Acceptance must be communicated to the offerer or it is not effective. Okay, though we have skipped offer is something that has to be communicated, so is acceptance. Always the law is regarding to offer acceptance, communication must happen. However, acceptance can be which we'll be talking about, but I'm just thinking of we'll be going to some of the cases. Okay, so I'll hold my thought there. So you can see that these cases, acceptance may be by express words, action, or inferred from conduct. And if I may show you, conditional acceptance. Okay, here's a Maldives, some of the precedents in Maldives. Okay, I'll be showing you as we go along. 2019 Supreme Court case 81 and offer acceptance invitation to treat. We can see 2019 High Court case 452. Okay, these are cases that you can read on the topic that we are discussing at the moment. Now, acceptance must be unqualified. That means basically you can't bring, we are here. And acceptance which introduce new terms is a counteroffer, which I've already explained. Okay, and a request for information in response to an offer is neither acceptance nor rejections. Now, the question is, should you accept and should you communicate acceptance all the time? There are these exceptions. Acceptance, communicate, nukurias, masaleka noa haletta. Okay, so these exceptions. Amiliang communicate acceptance, communicate wang yon rule do kollo. Misalnya amalum masek effective accept nuko. So we in English or in law we basically refer to such situations as wave of communications. The offeree, remember the person who makes an offer is called the offerer, promiser, and the person who accepts is the offeree, acceptor, okay, promisee. These are the terms that we use for the person who accepts. So the promisee or the acceptor, if that person waived the right, then a contract would be formed. Okay. Acceptance by prescribed means. Okay. That is depending on the type of transactions, it has to be in a certain way, and such would only basically happen without formally communicating, and such situations would be validly fine if if the method is something that has been practiced. Okay, and when there is no prescribed means, then the offeree must ensure acceptance is understood in the case of instantaneous communication. Now we'll be moving to the famous Postal Rule. It's actually in law school. I'm pretty sure some of us might have found it quite difficult, but it's not something that is too much of a rule. The simple Postal Rule is when you post your acceptance, the moment you put it into process, to, let's say in simple ways, the moment that you put it into the post box, remember it's only for acceptance, for nothing else, only communicating acceptance. The exception is that once you put it into the post box, it is deemed that a contract is formed at that point. That is what Postal Rule is. And remember, you can't apply the Postal Rule for communication of offer, revocation of offer, that is bringing your offer back. You can't use Postal Rule. Similarly, you can't use Postal Rule for revocation of your acceptance. It is only for communicating acceptance, and by post, this rule, it is said, that was developed in a time where there were businesses happening between New York and London, and it takes time to cross the Atlantic. And when the acceptance is shipped, let's use the term for now, when the letter of acceptance goes by sea or other ways of transport, the offerer usually doesn't wait for the acceptance. When the person accepts and when the letter of acceptance is received to the offerer, he usually would have sold it to someone else. So, as you would know, common law judges were developing it on instances based on practices. It became quite of a problem. I mean, during those days, two parties accepting and one party has already got the product while other is claiming that he has accepted. So in order to avoid this hassle, this rule was developed. So that is basically about Postal Rule. And of course, the instantaneous rule is there in today's words, as you can see in Torres vs. Miles case, one famous case in the 1950s, where the parties had to decide on the jurisdiction of the court, and the jurisdiction of the court could only be determined after finding where the contract was made. And it was found that in this particular case, that telex was used, and that telex in today's world, fax or emails, it is basically for these type of instantaneous communications, when the actual email or fax, when it is only received, then only a contract is formed. Okay, so it was basically in this particular case, the telex was received in London, and therefore it was decided that the place of contract, where the contract was made, is London, and therefore UK courts had jurisdiction to hear the case. Okay, now termination of offer. Okay, an offer may only be accepted while it is open. right? Now, offers can be terminated by rejection or counter offer, or when there is a reasonable time and that reasonable time has passed. Now, what about a situation where the time is not specified? So that is where reasonable comes, right? Now, determine Quran. It depends on the type of transaction. Misalaka, share market ka kunfunyege share value badalu mundawa guteka. It is decided in Ramsgate, Victoria, that you can't, this case, wait till share values badalu and them for. Okay, so basically, in this case, one party basically wanted to sell shares, and the buyer, sorry, the buyer offered to buy the shares, and the company did not respond. In other words, didn't sell. And then the following months, the company's share value dropped. And then they sent the letter of acceptance. And this basically buyer didn't want to buy those shares. And the company is going to court here and saying that there was an offer made by the buyer, we accepted it, and now he doesn't want to pay for the shares. The court decided that this is where the reasonable time comes. It will not be there indefinitely. Okay, failure of a condition of the offer. Okay, we are moving on. Offer can be terminated by failure of a condition of the offer. Basically, if you say in your offer that you have to come to buy my car wearing a blue suit, I'll be only selling it if you come in that. So if the person comes in a black suit, then you have, basically there's a failure of a condition that was put in the offer. Now that of one of the parties, okay, is a situation where the offer will be terminated. And then we have revocation by the offerer. Okay, the offerer can revoke it. Remember, before acceptance, always offer can be revoked before acceptance. Now, how is acceptance happening? If it is instantaneous rule, if the methods used were of instantaneous, then offer can be only revoked before it is received to the offerer. If it is postal rule for acceptance, that is, the parties were contemplating that the form of communication would be by post, then revocation can only happen by the offerer before the letter is post. I hope. Okay, you understood. Now, that is the general rule. But there are cases here, as you can see, Byrne versus Wentian-Owen case, posting a letter is not sufficient. It must be received. A reliable third party can notify. Now, is there anything that contradicts to what I said? Can anyone tell me with what you are seeing right now? If you are seeing my screen, we talked about postal rule just now. We talked, and this case is there, posting a letter is not sufficient. Is there any contradictory statement that I made? Can anyone tell me, just to check whether anyone of or all of you are following? Anyone? You guys are there, right? Just let me check whether you uh, can sense on the yeah. So basically, there's nothing basically that contradicts. Remember, I told you that for offers there's no postal rule. So here you see, posting a letter is not sufficient to revoke your offer. Remember, I told you postal rule is only applicable for acceptance, communicating acceptance. So if you want to revoke your offer, you being the offerer, let's say you wanted to sell your car, you posted your offer, that letter has to be received for the first time. So then only offer is communicated. Number two, if you want to revoke, you send a separate letter, let's say letter number two. That again has to be received by the offeree, i.e. the acceptor. Okay, that is what is mentioned here. So I hope you guys are following. Now, we'll be moving to consideration, but can we have a short break of 5 minutes? Admin, will that be okay?
هذا مثلا ينقطع.
So I'll be starting at 5 p.m. Okay, now the clock here is 4:55, so I'll be taking a 5 minutes break. Oh, that is, oh, sorry, the phone time is 4:53 at the moment. So we'll start again in about 5 p.m. Okay.
السلام عليكم. lecture feshito miharu kasi Fayyaz. Argon menang aden no libe.
My apologies in it around as well as coffee around hikuri me around gagan come five ga fattagen midani den kaivis wefla kangan buni kama beligen mi devuni
අඩන්නීව මිහාරෙක්කම
වර පොඩ මාෆිගේ තවුන්ඩ මියුට් කුරේ ෆුරිකන් නේගොනි ඒගේත
එරංගලවා නැබෑ තකුරා කොල්ල මිය නොන්තෝ
මේ මිහතන කියනෙත්ව වෙස්වාලෙන් බොත්තෝ නුනි අනමි වකි ඉංග්‍රේසින් ගෙන් දියුමාමි දිවෙ බවුන් ගෙන් දියුමා කොංගොතෙත්තෝ මේක ප්‍රිෆර් කරවනේ
ඉංග්‍රිෂන් ගෙන්දිය සමයගේ එකමකු දිවහින්ගෙන් ගොස්සීයාම අන ගෙන කුතින් අලුවන්ට හිවනි කොන්ට්‍රෙක්ට් ලෝ එක්කමක ස්ලයිඩ්ත අලුවන්නස් කියවාදිංගරු ගෙන ඉන්නනි ඉංග්‍රේසින් ගෑස් එකම ගෙන ෆාරෝ බොඩු බෑ දිවෙහින් කියාදී ෆින්න අනි දැන් එකමකවම එගේන දිවේ ඉංග්‍රේසින් කියාදිනකස්
ඒකෙන් අම දෙබෑ එක්ක කහගොතකක් ගෙත්තවා දෙත්තෝ අල්බර අරුන් හම මේ ගඩි ෆහෙන් හායි සාබුන් ෆෙෂිගෙන් මිමි එබ පුරිය ගෙන්න්න එක හොමි මයිකු අදව් මේ දක්කන කොන්සිඩරේෂන් ගේ වාහක මුගා බිල්ග දෙවේ කොන්ට්‍රෙක්ටුග මේ එච්චක මේ රිෆර් කරනමි කොන්සිඩරේෂන් එෆරාතුන් ගෙල්ලිගෙන්දා අනෙෆරාත ලිබේ නොනි බදලු කුරවේ ඒ කොන්සිඩරේෂන් එක මේක ඩෙෆිනිෂන් වර ෆුරියම ඩෙෆිනිෂන් මේ කියරි කේස් අශාරස්තයක හැදිය ෆහෙකමි මියති නිරස්ති ෆරාත ගෙල්ලිගෙන්ද අනෙෆරාත ලිබේ එච්චෙක් ගොත මේ ආම කොජ්ජුම්ද ගොතෙක්ග මේ තිම්බාවතෙක්ගේ considerations mi uleni egitere valid consideration getere mi folwani executed consideration na executed consideration naki mi contract hada wagutu amko badal kureve taketi misalaka mige me furihama misal dekkaleweni fiharek muda ganne iru fihara fasa hawal koffa fihara gelligenda chiki fihara guri muda fihare libe chaki adi ganna mi hatun gelligenda chaki ei fasa emima ei executed consideration ni misali executory consideration naki mustaqbalga mugabil hama jessun wata dena goteka medu ibas we for on otun mi nuktaga muhimmu point aki muhimmu ko faha kollum benuwa kama ki war gina fahara students sunna mi olun ara kame mustaqbalga kame kuran oefa ekamen adi wefa neti amu eta contract nete ei mugabil ga dibenchi heti libifaneto misalaka ebbasumen hadafa adi fasa atan libeni hemima eggotaka vis argue koggen numane fasa nulibe timanneka hemima contract nete no contracting eboen ekamako contract to badaluwan je e consideration agree wefa win me contract hedi wagutu misalaka me timanna dena me inha sufia phone wikamati emime yoti ebbasume phone gatuman ebbasumen hedifa e fasa nulibeni එහෙම වෙච්චාම අදි මියන්න මොහ මුසාර ලිබුණීම ෆෑසා දෙන මේ ඒ executory status gain consideration එහෙම අදි ෆෑසා ඒ මුගාබිල් බදල් නොවිකම ගවියස් contract on that එහෙම මේක definitions ගමන් this is a promise for an act in the future i.e. a promise to pay for goods later එහෙම ෆෑසා නුලිබුන් ඒ contract එක නැති යනවා contract go bunefo e gota fasa nudibigen yolani contract ay gota amal no kokki ehma mihara contract nete that is a wrong argument okay then menani past consideration naki kurige hinga adiya kame contract alan fahum hada contract ge mugabil ga noni consideration ge kotuga hamajessu media mi mahu miha ko mata sate karu fiyadini miyadu contract mihedeni kuri do media mahuga din sate karu fiyaga badaluga hingashe galam magatuga galam ganna that is wrong abatus contract hede hisabu fishing kuriya consideration move wani I hope you followed. Then consideration ga me adequacy and sufficiency me muhimu baiki consideration ga e agin hunnan jehe chetto agu jeheto e badal kuremunu mudala evvaru wala kavva ya e kashigenwa aga kavva ege jawabaki giresi munakama banya adequate wa kanu jehe kommeves as long as again huri echebe jamo it is sufficient it is enough maneki theoretically for the purpose of contract kitemme agubodo keves errufiaya misalaka vikkidane contract ege purpose an aharbe consideration ge beenoma bada kama banyama consideration yati de then of course hisabun adi masalani muni kiyenno e contract ge consideration element okkama faahage ngejeni then misalaka mege terega oluwalumen uleni to mi game mi vikkali misalaka errufiaya ehenkama banyamo ei dawlatuge idaarayakan e denjihe text nudekkumuge meenumuga nuni kommes uluwalumen otito miheka birudakkagen to ikankam bala iru einkamegama nuni buddhi salamatun hurito mikankan belumaki e fawka eka consideration purpose ega agin hure komme chaki ei mi Armin kiyawa fonani Chappell and Co versus Nestle ko Nestle chocolate ga honna rappers aki agu muri echka vati contract okkama kotu nimmi case e case aki saaf vejito ehmima point aki mi war carefully mi adwasawat consideration law of contract the general contract ge beenuma ei vikka echkanuni contracten hedigen dairu echka ekashigen wa agakavwa kanu jihe fudinyamu agin kama belive kama banyamu e badal kureve e ma mini gimsa e rufia e kami goche vikali e misal ko mi fahaga kuri nukta e ki consideration ge beenuma mugabil ge beenuma niyati mugabil okkamashe ehennamaves e fada contract ga itura balan jihe kankan hunnane ha bodo aguge farage huregen ebbasume miyeko hedi kiwe to den mi emima fude mi marke buna vidano ni sufficient e emme commes agin e huri kama vanyamo e consideration oti den mienna anen muhimmo balki performing existing statutory obligation is no consideration for promise of a reward obligations nuni miko ada kurunchi masuliyat nuni wajib take kiyama mi muko contract ga hame mi mi beno kurani mi hege masuliyat ko mi hege zimma mi hege aamu kotegga mi hege poduga zimma mi yele tingo tenge bove eggotaki ei dini gotonge mi hege ada kurun jehe wajibta wata zimmata devaneya mi kanuni gotum kanunega waki kotaka waki kankan kuran wonnati ganu misaka text dekkun ei kanuni obligation ne mi divine law ya mi annakame misalaka namad kurun contract law ge teren mi midenevi text law ge teren text dekku insanon hata mi legislature en fast kura ganu mekke dashon den timmana gotaki mi hegge boduga masudiyat wata zimma ele timmana gotaki contract hedu emima alan hada contract ga kurin mibunu debawatuge zimma en ei ganuni gotum ena da kuran je zimma en wata dini gotum mi den log teriya gima by halata ko noni by fetta ko ge buri statutory obligations sa mi dini gotum an obligations sa in obligations that come up with. Okay, I hope you are following what I'm saying. Misalaka mige misali dekkima mi point clear wane text dakkam yon ani ganone ke dashon a statutory obligation ne ege matcha mi ko contract mi hadani demi ko text dakkashe misalaka deratte hin eka koneka kommi burani kale text dakkashe text dakka matin timanna miene adadaka fasa deedame kale zimmaki hame kan text dekkume that is not valid contract. Why? Because there's no valid consideration on one part. On whose part? Performing existing statutory obligation is no consideration. Mihako contract mihadani ganuna kongena kurang ekkame kurang. Ikan kuraka mige ehem misale dek mabanya misale kotu amure mihege matcha fono ifamiyati heki bas dinuma anna kotan anna den ena kommehen e kota gennam beenum wa miheko masalaga hasmun getere miheko punani kaliya dename enha surfiya kommehen bas madama kota gosunnet then you can see enige matchan ibon kota amuru ene receive uma ekkon ena kota diumge obligation statutory obligation then ena obligation oy feyna gira ratte mi hanoni mi masalaga hasmun getere mi bunai fasa dename kota kommen gosunneche ehem bunefa otima mina kotan eduho haziru fe koto enage e kotan ediya gendiya sababa nimumun anika ko matcha mitawa kuri timane denje fasa in has to fianu digenne timana minuledi in that case you can't claim that because already kanune gedashon ena kuran jehe kame kanune gedashon mi kuran jehe kame contract to buy kan hede that is the point namad kurashe namad kurima me lari de name a contract sahain I hope ekamako misala e ganune mingada bure itura kura ba iya ene a contract to buy kame kuringa harmen ni ki misal koto amurelli before na miha ena mi bunani timannen aadiweeni mi doonyegge misalakan e heki basnaga koota timanataku faasanete eka kommehen ena kootan e gennam beenunga misalaka dawwa kura miha hushala hekke ena mi bunani dawwa kura miha mi bunani annashe launch haya kogge timanna laari dena. Now that is something different. Ehaalatuge launch haradu ene claim kure vidan. I hope you understood the difference. Mige hama misala ki contracting hedi fotas envima as law students kuriyang tanga case taka hawal waru misaka faa kuri fo dane contracting gamiyati waki muddataka mi contractor mi baswani imara ko dinuma e muddatu ga imara nukko anikka e muddatu tereng waki hisabakon as muddatu hamamuge kurim me bunane adi ebajihe timanna yang itura million den erashe e muddata tannin meni defarata kon soyel ko e basumen hediyas e saha e basumen no ifaraton yoti e consider ham kulim bes furtama hedi e basumen gala romes e consideration yoti e imara nimma dino devane basumuga itura mi annani million ge mugabil goti hama kurin e basumuga scott dem boni kanta ehem wejji am devane basum e saha e basumen no because consideration in ne ehem e basume ge dashun already in e basume den harmen balal mami consideration na gule goton hori mugabil la gule goton hori bay case takaki de has fas fana wana harga supreme court ge service number gazia de has namara wana haru supreme court ge fansas havana gazia de has na mi de no mi eki nuttata cover ko hori bay gazia ta mi promissory estoppel mi is hama rajege supreme court bas balagan fava mi usule promissory estoppel aki kobato where one party makes a promise which is not supported by consideration, they are prevented from denying that they made the promise if it was made with the intention that the other party would rely on it. Waiver of rights is only binding promise if there is consideration. General rule aki asharas teka addi hatriga Fox versus Peer case mihaku mi ene libifain hagge dukolla kama vanyamo e hagge dukollumuge badaluge ene ecce liben ibajje consideration onnan ibajje ehe namawes mi usul miharu yani e general rule laka badaluge fa adi ege exceptions taken e bahuri mane ki mihako hagge dukolla kama wanyamo e haggen ena dukolla af kama wanyamo fahun ambura enia ena dukolli ecce hodan kota adevikin nuane sababaki ena vi waud nuata enage promise ena stop kurani ena kotan awma nuni e haggu hoduman awma hurahaka wani ena ge ena kuri waud timanna denti fasa hoda kan nannana sharut takaka eku mi usul apply kurani en kamon miga nukta yaki waude vejjamu e wauduga consideration nane ekakotun ekakota da nuni ekaka libe manfa ekaka libe gellum mi dennevi mi geteren effarata burawa gota consideration e fennan kanonnane hagge du kolla halatikka mi ko wawde mi woni timanna yangi bote mi fasa hodan kota deven ekamako kadege halata bala fatimanna kota ka timasale no daname timanne libenti he fasa du kolli timanna eves e halatuga e ufedeni a contract miga itura tafsila da kama banyamo ando bunafan furtama mihiko mi de mihiko mi hadani loan e basum loan nin ekakwane kakoto nagani naga fa fa'asa nudekkeni buna duwa fa'asa nudekkunima loan dukuri farato mi bunani den timanne fa'asa dukolli ehin e bunani e yene wani waude a contract a promising ene e halatuga wujudu e to mi balenjeni mi ashar stake adde hatareke case Fox versus Beer mi buna ni mi common loga hunna bay sifata mi case ta mi fenigindani wara specific contract ga hunnan je element ge tereng element ke consideration naki haggu du kollan e buni miha e wawdwi wagutu ene libeni coaching he ene libe chennete in other words there's no consideration for him ekamako anikayan e ba faada libe that is wrong ehem wima alun enen hama ena wawde befotas kota devene ehenamais e mi kesa guligen ingres vidataga legal e mi fada court takada wakiluna adi fandiyaruge metuga bahus ufedigen dia case mi kesaki mi emmerangalu goitto adi emi honga bokura dini hamataka equity ge mingalu takumbes emme rangalu goitto consideration abadus oitto balenje heto consideration netiyama anekka vis mi wawde vefaves anekka kota deveto I hope you are following ihen kam fahun mi usul mi badal wegen die exceptions taka ko egoton exception ki promissory estoppel mi hako promise ko fikama banya wawde vejjam timanaten efasa hoda kan nanna mi puna fikama banyamo adi ege maccan aneka amal koffi ene ihata nan ikkura mun e fasa mi haru ene hen kama ka benun kofi lono ada kuran ene bahattaage madum ituru kuramon midiya fasa ikkada wawduge macca timanati fasa den hoda ka benu me nune bunima ege maccan amal kofi kama banyamu yati promissory estoppel le meti promissory estoppel le onnane halata promissory estoppel le nonnane halata promissory estoppel is often argued to apply in cases where part of a debt has been written off. However, where a party writes off part of the debt just because they need the money quickly, that promise is unenforceable by the other party. The promise was not given with the intention that it would be relied upon. It was not given voluntarily. Me Fox versus Beerga kan hingati gotaki misal mitanga mi oti hamma milone ge fasa dinuge muamalat Fox versus Beerga ekamako high trees kia kesega mi narsek sari satega mi usul badaluwegen gos mi mi usutake promissory stripelge usul fenigen harmina midie. A landlord agreed to accept reduced rent because of wartime conditions. Devana bodo hangurame fahu business davve fotima kuli kuda kuri. After the war, they sought to recover the rent in full. However, the promise was freely given and the defendants had relied on it. Therefore, the reduced rent for the wartime period was upheld. Special circumstances, i.e., war, applied. And carefully miti apply kuran jihe ni waragina factors taka peligin ena promise kof wati kongo takatto enage promise ki sababun ena puttu veto emihe gamilla promise emihe ko huttu ani emihe ge haggu hodo ege ituru sharutta mi ituru case takuga ena million e promise ki ena voluntarily then let me move colony intention to create legal relations mi contracting hadairo niyataki ei amuko fennan onnani chennu niyen onnani hituga nuni niyataki sikundiga kama beli kama bis ei ege zaatuga niyat denenu ganevene ikamako niye beru fusha fennani amalu we all agree on that then misababa taka presumptions take court takon mi ufan kuruwa fa mihiri usutake ufan kuruwa fa mihiri niye denegannane go contract takagule gotum contract hediru niyan etto nota nunto balan mi ufan kure furi usuta case loge zariya egotum mi contract ta debayka bahale fa mihiri domestic social family arrangements mi bawatuge contracting hadaf kama wanya domestic no mane ki geveshi aila ge memberunge bappaya tarifula noni bappaya mammaya kummes kahal fasagi noni wiefari ge muamalat gota sifa wa gota muamalat ke kure famige liwum besse bahuri ehen nama bes kotum balani general rule laka niyaten wegen kure bunu kamen mune intention niyateke mi danoni enforceable in a court of law court da visnumuga nuata haggu hodan mi ganuni gotum maseki kuran halata visnafa kurikame nune misalaka bappeko mi punani dari fulkari rangala kiyawagin rangalu results university in genestation era bappa kare gani dename dari fulu mulin huriha modules takakun distinction hodagen emme molo dariwaragu gotuga fast with university fast wima dari fulu bappa kelma nitimanna denche karu ko bay bappa karu no dinima suwala ki kotan anna අනෙතෝ දරිෆු එම ඒ බාවතුගේ කොන්ට්‍රැක්ට්ස් ත ඒකි කානූනී ගොතුම් පදෙවුමුගේ නියතු ගහදා කොන්ට්‍රැක්ට් එකේ නූනේ a general rule. But just remember, in law there is general rule and exceptions. In court, aumuge niyatuge hedi etchenoni kanuni gotum pandeven kuri kamenno a general rule. However, if the party that is claiming can prove in the court that it was intended, then court would rely upon it. Okay. Remember, general rule laki it is not intended ekamaku party of the furusat dene enun gotakkan ekan higi sabit koddinuma niyata ekukan e university fast hodima mola fast wima karek gane dem ebbas wi ekan sabit koddifi kam banya ai hama contracting hedumuge maksadu korewonu kamekkan misalaka court ga registry wes kofoin ebbasunen ebba bappya darifula ikaha kankama ki beenon kure vidane mi heki sabit kodino hama similarly commercial agreements ga mi onna gotaki samaseka viafarige muamalate bayakum mi hanko fiyam kotum dekeni nuni ganuni gotum beleveni e ganuni gotum pandeon ganien ovegin hedi contract kama ekamako fursatu eruena misalaka timanna men samaseka kuri kamiketi tibbasumaki ehem bonafikama banyamu ehem bona mehako jihen ekam sabit kodde ehen noni kotum balani viafarige gotum pandeven adi ganuni gotum pandeven defaraton hedi ebbasume kam misalaka dekum funyakon bodo viafarige ebbasume kasse ko fami bunani e timanna men hama marketing nataka kolli kamiki aslu ebbas won bag kuriyedimuga ne etuga kuri kamen mune efaratum mikulani ehin efaratum bunakama banya efarata njehene e kan sabit kodde e noni kanun ge kurimatiga balani enien ovegin you know the burden of proof e sabit koddimuge buro fulan jehe farataki e dafu naga fara then me hama me I remember me how me at this me you guys are not students anymore so visnu miha bahatan jeheni abdu skotan masata practically ahar mengeten ahar ko law school te ko mi kiyevi theory practically masata kota wadda kota ganneru visnan jehe bakkan e privity of contract noni contract ha mi gulifati bi mi hunge matche kowe dawato mikahala kankan mi balanje kankan war ginafa the practical aspect hopefully madama we will be talking more myogoto privity yaki kobato only a person who is a party to a contract has enforceable rights obligation in it third parties only have a right of action in exceptional circumstances maniki defarate agreement A versus B contract en hadani A ya B ya C yakanna devene e contract ifagin kotaka e C ge privity enne C ya ves gulumenne dawa kuranjeheni e ebbasuma e gulumen huri farate nota mitaga mi bunani exceptional situation timana farata kon e dawa kura kam panya ene wang gellume nuwata ene wang fada ega fen innaman den ingires filatoga mi kamuga miharu amal kurago taki rights of third parties act kya kanune ke dashum mi ba e kanunu ga buna sharut furiyama wa hale tagga timmana farataka mi fursat mi onnani da'wa kuran timmana farate haysiyato yanka mi visnalen jehe contract ge bavering amuko aharme divi contract ge baveri noni yamu contracting hifagen ege dashon haggu hoduma e fursatu am usulun eruwe gotakan nummenani ene ki ya gulum huri farate kan ene sabit kodden e beje emema mihar mi fahaga kolle wono ni amuko contracting hadairo ni contract furatama bakiyama the first part of contract law that covers essential elements of contracts okay magando gotegga a offer acceptance consideration intention to create legal relations mige itula den ade capacity e miheki contracting hedumuge gabil kan huri farate to mi amko gina fottakuga himeneni hushehelun gabu kurun mugabil otun ganuni gulmen ufeddumuge nien otun contract ufeddumuge gabiliyet kan huru adi ruhun otun consent mi harmi mi harmi kuriya mi balalam mi da notes takuga ruhuma mi kan kan anare hen topic ka guligi hen mi baga iba mi cover nukomiti ei contract tuge sahakaman asar kura kan harmi fahun adi badalana contract tuge sahakaman asar kura emme bodo e gotaki ruhun kan wota nekkan e elementa gure goto okay ibe sualen e botto ema furatama ba mi moni elements taka gure goto den miati contract meharo elements tak furihama wegen contract e wujudu ko ekkama miharu mi balani bala halatu den e contract go madda taka non e contract ge liefawa kankan muta content mi content taka jehila iru content diumuge kurin asko contract ge content contract na hada iru fennani ko chekka to contracting hedi memmen wesi wara bara kiyane e terms ebbe kuyan terms and conditions ekama ko contracting hedumuge kurin echi hi fennani kontana konto eya contract loga mi devi fa mi onna namaki mata e mi kiya ureni contract wujudumuge kurin ebbas misalaka phone ek gannan daamiya fihare wad mihani mita mihiri ebahurihe misalaka iphone emme fahuge iphone 14 pro max ebahutte waki kulen ebahurihe e kulewes ebahurihe agu waki age eves tia mi agashe mi phone migo tambi furutama mi kuriveni defaratun wahake mi negotiation stage ga mi dekeve wahakata miyam mi kiyane representations එහෙම මිතා හම මිති වික්කම් උලේ ෆෝන කීනුනි මිතා වික්කම් මිහිරි හුස් ආෆෝන හෙයියේ උනේව ෆිහාර වික්කම් හොන්න මිහමනේ හුස් ආෆෝන තකේ රිමෙම්බර් අදි කොන්ට්‍රැක්ට් නෙහෙද මිදිකේ වේවා හකතකකි මි representations contract එක මිහකු මි වන්නනි මි representations ත හිඟුමෆහු ඒ ගන්න මුලේ චෙග්ගේ සිෆකෝ ඒ හුරිහා කම හිඟනි ඒ දෙෆරාතුන් එබ්බසුමකන් අවුමට්ටක මි කඩත්තු කුරා මරුහදා එයම් මි කියන්නේ representations මි මරුහදාග එවස් ඔළුවාදුමෙන් හිඟෑෆකමඤ්ඤ එයම් මි කියන්නේ misrepresentations ඒ යහරමෙන් අදි ඉදන් කුරින් වෙස් පුනිහෙන් කොන්ට්‍රැක්ට් එක සහකමන් අසර කුරාන කොන්ට්‍රැක්ට් හෙදුමුගේ කුරිය වෙස් ඔළුවාදුමෙන් ඔය කමපඤ්ඤ ඒ විම ඒ බයන් අහරමෙන් ෆහම් ජිහිලාන එකම මිහාර එගින් බේනුවා බයකි representations are anything which induces the contract I mean contract එක මිහකු හිජ්ජසුව contract එක මිහකු වනුගේ කුරින් එහිඟා මුවාමලයන් එෆේස් සම් කියන්නේ representations face ඒක තෙරින් හුරිහා HSS contract ගේ terms තකක වෙගෙන් නුදාන contract මිසාලක ලියෆ contract එකම බදම ආර්මගේ මි ලෙක් නියෝගතමි topic ke beenuma e wagu contract ko soy kura hisab defaran ebbas wege liumat tiri ko efuna lium ga ehunna huriyaach saki eyam kiyani terms ekama ko remember e terms takaki e representations takuten hoali webe e huriya representations ta contract ge terms takutere nuade e defaratun ebbas wevunu goittakaki a contract to get terms takaki a legally binding agreement must be complete in its terms amuko e terms taken hunnane ekama ko terms ta fennen hunna halattakuga terms ta agree nuwa halattakuga usul taken e bahure nuni ebbas won saaf ko nufenna halatta terms taku wedan ei mibuna hen kurim wes arme fashagen giriste ke market price abada fa demi he ko ebbas me before wedan he ja terms tan egen geni market ka e bawtu ge muamalate e ko me duha ko agu misalaka iki duho iki agu ga hunna echi gatuma demi he ko ebbas dan misalaka ni market local market එක වික්කම් හොන්න කුරුඹා කාශි මීතකෙති ගතුමත් දෙෆරාතකුම් එබ්බස්ුමේ ඔවිදානි එකමකු දෙෆරාත විස් ඉගේනේ මාකෙට් එදුව හෙක්ග කුරුඹාගේ අගුහුරි වරෙක්කම් එදුව හකප්පේ කුරංචියනි එම එගොත ටර්ම්ස්ට ඒ සහ එහෙන් හොට්ටස් තිමන්න මෙගේ ටර්ම්ස් තක නැතෙන් නොහ ෆෙන්නාකන් එක දුව හොය ගොතෂන් නොහ අගුහුන්න හෙම සහ කොන්ට්‍රෙක්ට් නැත නෝ එහෙනෙන් නුබෙලවෙන් මී දෙන්න වුණු ටර්ම්ස් ගේ තෙරෙයින් මි ටර්ම්ස් ත මි පහලවෙනි දෙබයක ඒ මෙහරු remember where we started representations තක් ගේ තෙරෙයින් contract mi hadani hin hama jihe gota representations taken noni negotiations taken hingim efesam mi kene ege teren hoalive madda taken noni terms taken if defara ves ebbas veve terms taken match contract me hadani hada fa e contract to e terms ta anikka mi bahali veni tibayaka ege teren muhimmu terms taken mi kiyani conditions em amu bahurwaga terms and condition e bas beenon curious terms and condition e bas beenon curious remember as lawyers you should always know that term geteren wattare kan condition naki okay general business community you been find terms and conditions, but as lawyers we have to be careful that a condition is an important term which is so vital to the contract, which is so important to the contract that breach would destroy the agreement. And contract baatil kurevidane maaddata එමාද්දායක හිලාෆු මුන් contract බාතිල් කුරවිදාන මාද්දාතක කම කියන්නේ conditions e contract ga muhimmu maaddata divehi bahum me benu kurani noni aw men court tak yani hukum tak belum mifada maaddata kam කියන්නේ contract ge jawhari maaddata e jawhari maaddayaka hilaf vejja contract baatil wa jawhari wagut e jawhari maaddata contract ga waki gotaka bayan koffa hunna hale tabga waguta meto ek contract ga bayan kora gotaka nimmaali misalaka deharu terega imara konnimma e deharu e jawhari maadak to nunto so miyan ebuhuri usutake kandelifa unless otherwise mentioned in a contract unless otherwise mentioned in a contract time is of not essence hennu emmembes wagutu hifagen wagutaki ei contract ge jawhari maaddaykan hada em contract ge specific mention kuran jehene e mi contract ta wagut ge muhimmukan e muhimmukan nege kama egota bayan kuno pura kama banyam ei komme muamalate kiwes wagutu egetere ekudevegen bakam ehme huriha wagutaki ei jawhari maaddayake bunafiyama wagutan hama fuyama nuwa kommechi jawhari maaddayaka hijafi kama bani ehme mi waguta gule gotun e huri usutake kandef then yoti warranty e warranty ki minor terms ekamako harminge niyada kandele fawa wagutu hama vejje ehin kamun men mugutaka mi ba huttalaane adima dama haviru hatara fon hayka mige aron kuriye tenda itur session en adi fahu session nonnane enes mi session hama nimmaamge kurin aronduge mi adu saaf ko libe mundiyeto adi
Founder mastade loje
ehto kineto anehi mi genda gota me do ebotto mi hiyale
non fahun alondu dannawati me misalu devve warappudan etikala handam bes pure adenti kawarappuda golutti dan den ambugotik gama kiyawa puriyecchi te dekum sagotti enetia explain koddevaru misal da mekkala exam bes ek handan tam nanta ehma e tituru koddum alundu hiyalen eti wara constructive warahama ege waranawal
definitely betto itru commenting era me madan session daru eben himene to balana para gina befront tibbe kamang iba fene enmes itru hame bes beflo ko eche vidal noveto එහෙම ජාම දැන් අලුම මිය දක නිම්මාදාන ඇඩ්මින් සයිඩුම් එබෙන්නේ to
ade eves beflege sualen netto hama
nekkama බලමදෙත්to
ade එහෙම ඉතුරු සුවාලෙන් එක්කම වවනවා මිහ හිසාබොන් අල්ගොන මෙ මිදච්ච නිම්මාලාන දෙම් බා කවුන්සිල් ක පරාතුන් හම ගාසි අලුස්තාස් ෆයියාසා වරපොට ශුකුර තන්නවාලා දැන් මියදුගේ lecture session recording Teams platforming ෆෙනි වඩා ගන්නවන වහක විස්තන්නවා ලං අල්ගොන අප්ලෝඩ් කොල්ලාන මිහසබ මියදුගේ lecture අල්ගොන මනිම්මාලාන lecture එක බයවර වඩා ගන්න වෙති හුඩ බෙෆොන වඩ බඩ ශුක්‍ර තන්නවා